Hello there, Attorney Andrew Bethel here with a little Q&A, all on step-up in basis when it comes to inheriting appreciating assets. Today, I just want to address some common, smaller questions that arise when it comes to step-up in basis. Each question alone might not be enough for a whole video, but together it should address some common questions that people have and likely one that perhaps you didn't even think of. But before we dive in, thank you very much for watching. Please be sure to hit the like button, subscribe, and ring the bell to stay up to date with all of our videos, all on estate planning, finances, real estate, and taxes. And without further ado, let's dive in. But really quick, let's do a quick refresher on what a step-up in basis is. When you have an asset that grows or appreciates in value, and you sell that asset, you typically pay some taxes on the profit you made from selling it. Those taxes are capital gains taxes, and we figure that out by determining your profit, which is the difference between your basis and your sales price. Hopefully that difference is a positive number. If it is, that means you made a profit, and thus you owe capital gains tax on that profit. Your basis is typically your purchase price. There's ways to adjust it, specifically when it comes to real estate, but generally speaking, your basis, your floor, is however much you paid to acquire that asset in the first place. Now, if you were to give an appreciating asset like a house to somebody while you're alive, for instance, I gave my house to my son, then my basis in that property transfers along with the asset to the recipient. So in that case, if my son were to sell it, then he is going to pay capital gains tax on the difference between what I bought the property for and whatever he sells it for. However, if I were to keep that property and don't pass it on until after I pass away, so my son receives it as an inheritance, then his basis in the property steps up to the date of death value. At that point, then he sells the property. He's only on the hook for the appreciation, the growth in value that occurred from my date of death onto whenever he sells it. Usually, sell it within a year or so of date of death. We're just going to say that those numbers are the same. Thus, in that case, he would owe $0 in capital gains taxes because he made $0 on the sale of the house. So a step up in basis is when someone inherits an asset that can appreciate in value, whether it be stocks, bonds, mutual funds, or real estate. And when they sell that asset, they pay capital gains tax. Their basis in the property, because they received it as an inheritance, steps up to whatever the value was at date of death. Therefore, that establishes their new floor to determine capital gains taxes going forward. With that said, the first question centers around inheriting property and whether it can be sold from a trust or an estate to benefit from the step-up in basis, or whether it has to be taken out of the trust or estate first. Short answer, no. The benefit kicks in upon death. The asset can be sold from the trust or by the beneficiaries directly. In most cases, property is sold from the trust or estate, and the beneficiaries only receive the sales proceeds and a Schedule K-1 to file with their taxes that year to relay all of that to the IRS. Yes, you still have to file a return and tell the IRS you sold a house, even if there's not going to be any taxes owed. So at the end of the day, there's not really a tax difference between selling an asset from a trust or an estate versus the beneficiary selling directly. Of course, the difference is really the administration side of it. If that asset in question, let's say a house, is owned equally by 3 siblings, now all 3 of those siblings have to mutually agree as to the sales value, and all 3 of them have to sign all the paperwork in order to sell that house. Of course, if that property is being sold from the trust and only one of those 3 siblings was the trustee, it's a lot easier to get that house sold because now we've got one person in charge of that entire process. Once the house is sold, they just cut checks to everybody and send them the appropriate schedules to file with their tax return that year. The next question concerns irrevocable trusts. I did a video a few years ago where I discussed an IRS tax loophole that was closed by the IRS. Long story short, previously, if I put my home in an irrevocable trust and left it to my heirs upon my death, then they would receive the property at a stepped-up tax basis, even though that asset came to them in an irrevocable trust and was separated from my estate while I was alive. In that case, the idea was to separate the asset or property from my personal estate, and therefore it would not be considered as an asset of mine, but still allow my heirs to benefit from the stepped-up tax basis. However, the IRS no longer allows that step-up in basis for assets I place in an irrevocable trust. Thus, if I put that asset in an irrevocable trust, then it's gone from my estate. I cannot get it back. I might have to pay a gift tax. There are ways to avoid that, but that's a whole tangent. And my heirs will not benefit from a stepped-up tax basis and therefore would have to pay full capital gains tax on the sale of that asset in question. To put it simply, a lot of folks read that they need to create an irrevocable trust, put all their assets into it to keep it safe from lawsuits, yet still allow their heirs and beneficiaries to benefit from a stepped-up tax basis after they pass away. The IRS, of course, finally caught on to the whole process, figured, well, if you're going to take advantage of the benefit of creditor and liability protection, we're going to strip away that tax advantage that comes with inheriting assets. Now, if you put that asset in an irrevocable trust, it is separate from you. It may have to file its own tax return. Thus, the IRS kind of closed that loophole a bit. If you're going to benefit from the separation from your personal estate and thus some liability protection, then we're going to lose some of the tax advantages of having that asset and having it be inherited by our heirs and beneficiaries. So when it comes down to it, if we've got an irrevocable trust, we're typically only using that to accomplish a very specific goal or tasks. It's not a good way, at least here in California, to still pass on assets yet ultimately shelter them from our own creditors. You've got to pick one or the other. Shelter it from your creditors, have the kids benefit from a stepped-up tax basis. You can't necessarily have both. And lastly, more of a simple question, how do we even determine what the new basis is to begin with? Well, the answer to that really depends on the asset in question. If it's securities, like stocks, it's easy. We just look to the value of the stock at date of death. However, if we're talking about other assets, like real estate, then we need to, at the very least, get some sort of competitive market analysis, but ideally more of an appraisal to get a very accurate picture of what the true value of that real property was at date of death. Of course, when it comes down to filing a tax return and telling the IRS that you got a stepped-up tax basis, you're just going to be throwing some numbers down, but the IRS, of course, can always audit you, and if that were to happen, you're going to need some proof to show how you arrived at that number. So that's where that competitive market analysis or appraisal is going to come into play. Of course, this also applies to other appreciating assets, maybe fine art or jewelry and whatnot, but for the most part, for most folks, this is going to come into play with real estate. The family home that gets passed on from parents to kids. Acquiring a stepped-up tax basis is a huge way on how people actually generate generational wealth. How assets get to be passed on through the family without the IRS and the FTB for California coming in and taking big chunks of it all. It's a big deal, it applies to everybody, and it's something that many people do need to understand when they're setting up their estate. But when it comes down to it, essentially, don't give anything to the kids now, let them wait until after you pass away. It works out for them at the end of the day from a tax perspective. But with that, we discussed a few topics that center around stepped-up tax bases today. If you have any other questions on stepped-up tax bases, or maybe a question about anything else we cover on this channel, let me know down in the comments below. But for now, I'm Attorney Andrew Bethel, and I'll see you at our next meeting.